Good evening. This is Greg Bafidis, the founder and chairman of the Posse List, and we're here at the Georgetown University Law Center for the beginning of the conference Law Firm Evolution, A Brave New World or Business as Usual. Tonight we're speaking with David McGowan, who is Lyle Jones Professor of Competition and Innovation Law at the University of San Diego School of Law. And his specialty is, I would say, intellectual property. David, in a recent article, you had mentioned our favorite economist, Joseph Schumpeter, with respect to innovation. But tomorrow you'll be speaking about him with respect to the creative destruction and innovation as it applies to the legal market. Can you tell me more about that?
The point of the article and of our presentation tomorrow is to talk about the forces that are changing law firms in the modern economy. Some of those we think are basic Schumpeterian forces in which technology has changed cost structures and allowed people to do things they couldn't do before, in part outsourcing, in part achieving economies of scale at a smaller scale so small firms can enjoy the kind of economies that you used to need 500 lawyers to obtain, and putting that piece into the puzzle of the modern market for competition and legal services.
So breaking it basically down to say that everything is economics.
That's a slight exaggeration, but I do tend that way. You can't ignore economics. Clients care about economics, and you need to be responsive to them. You need to understand them and make them a part of your practice. We need to make it a part of legal education so that we understand the markets our students are entering, and I think it deserves a lot of attention.
Okay, tomorrow's event is going to include Mark Chandler from Cisco as well as William Pearlstein from William Hale. We had interviewed the Mr. Pearlstein and William Hale in New York last week. He went over many of the things that he's going to be talking about. Have you worked with these gentlemen before?
No, I haven't. I'm looking forward to hearing what they have to say.
Okay. Much of the work that you do at the university as far as the specialty, can you just go through that again for us?
I teach antitrust and intellectual property and legal ethics. So my interests combine the economics of competition policy, the economics of intellectual property, and then regulation of the legal profession. So to me, what this conference is about is a synthesis more of the competition side and the legal ethics side, the legal profession side, than the IP side, although some of those concepts are relevant. But I think I try to integrate whatever learning is useful to the problem at hand, and one of the problems that we're very interested in is the markets our students are entering and the markets that I compete in as a part-time practitioner. So trying to bring all of that together in a way that produces useful information is really the objective.
Have you worked with Georgetown before in such like conferences?
Not like this one. I've been out here and I know the folks who are here. They're a terrific group. But this is my first time here, so I'm very much looking forward to it.
But you've done or similar types of work at conferences before in this subject area?
Yes.
Okay. Tomorrow, let me ask you this. Can you summarize very briefly the main points that you want to make tomorrow?
I think the main points that we're going to make are to try and review the thinking that has gone on in the legal academy about large law firms and the delivery of legal services to sophisticated clients, and identify areas in which the prior conceptions, the prior theories, don't really explain what we've observed. So to draw a contrast between the state of the law review literature and the state of the analysis to date with our observations, and then do our best at explaining or taking a shot at explaining what's going on now and what it teaches us about what people have thought in the past and what predictions it might generate for the future. So, for example, one of the earlier theories of why we have large law firms at all was that it allowed firms to diversify revenue streams and hedge downside risk. As things unfold, that turns out not to be a realistic assessment of why firms came about.
Reason?
Well, it involves pooling, and you don't see a pooling of revenue streams, and that would imply a greater degree of lockstep or near lockstep compensation as people benefited during up times for them and down times for others than you actually see. You don't see a very high degree of lockstep. You don't see a high degree of revenue share, of risk sharing.
Which, based on the debate we saw earlier tonight, indicates, or at least Crookler and Ellis would have us believe that lockstep is out the window across the board. Do you believe that statement?
I think lockstep is very, very rare now and has been for a long time. I think at least since I entered the profession in 1991, people have been compensated for what they bring in. And Firms do that to a greater or lesser extent, and that leads to rich-poor gaps within firms. It leads to different sorts of tensions, but it's not terribly consistent with the idea that a firm is a pooling of risk. If it were a pooling of risk, you would see less stark differences than you do, I think, in compensation, and I think you would probably see less mobility among firms, because if what people are really after in a law firm is insurance, it's not obvious that one law firm is a better insurer than another, but you see a very high degree of mobility among partners, as was mentioned in the panel. So that's an example of where my co-author Bernie Burke and I are looking at the previous explanations, looking at the data and saying this is inconsistent with this story. There's some other stories out there. There's the tournament theory, which we think is largely unconnected to demand factors, and we don't think there's any plausible story that can be disconnected from demand. It has to pay attention to client expectations on the demand side. So we're basically suggesting that a lot of what's been going on in firms has to do with rationalizing the existing model in which clients are less tolerant of what we would think of as agency costs, of firms trying to get margin from work in which there really isn't a lot of margin, and in which technology has made different business models more viable.
Do you think that technology will be discussed in more detail later in the conference from what you've been...
I expect it to be a recurrent theme.
Okay.
I'll try and set that up tomorrow, but we've heard allusions to it so far. It's implicit in things like outsourcing, when people talk about having document review done in India, when they talk about having patents written in India. The ease of communication, the ability to have seamless cooperation with people all around the world, that's a technological feature as much as anything else. It's not as though they suddenly got smarter and we suddenly got dumber. It's that there is a convergence of talent, and that makes everything more competitive.
And that technological side, the pure technological side, is something that Richard Susskind has talked about endlessly, obviously, as in the end of lawyers, and he'll be speaking later in the conference.
That's what I understand.
Okay. David, thank you for taking the time to meet with us.
Pleasure.
Bye-bye.
Bye.